and sounds as such.
He appears
Very traumatized. He both looks it and sounds it. And therefore, because you are in court and the cameras were all over photographing us, I have not had a session to debrief him on the relevant matters that are the subject of these proceedings. Therefore, apart from him confirming his very deep fear for his life.
So he expressed?
He expressed, yes.
Yes.
I would like, and I request this Honorable Court to grant the family and myself, we have all met in court when I was meeting him, to grant time for us to be able to talk to him in confidence and in privacy. And since he still appears to be very traumatized, we ask that any time in the course of next week, we'll be given an opportunity to come back to this court, accompanied by him, so that he is able, and ourselves we are able, to be of further assistance to the court. I regret the fact that I cannot be of further assistance at this stage until we have had a proper session with Ndiang'ui Kinyagia to know exactly what was happening during those traumatizing 10 or so days when he was away. So that's all, my Lord. My Lord, Mr. Ndiang'ui, please stand up. That is Mr. Ndiang'ui.
Make your way here.
Make your way here.
My Lord has mixed his way here. Just for clarification, what my brother senior was talking about, the affidavit indicates that the deponent was contacted on Tuesday, not yesterday, so for correction of the record.
Yes, Mr. Stuku, I've seen what you're saying. So you want me to record you?
Yes, Your Honor. In any case, it's clear on the basis of the.
Yes, that's what I'm saying. I've seen it. So what were you saying?
I was just pointing out that correction.
Second petitioner contacted Lillian.
On Tuesday evening.
Tuesday was first.
Yes, the 1st of July.
Is correct.
Thank you. You can go back. You appeared to have beards. Now you can take your seat. So who else wanted to say something? Petitioners Council?
My Lord, we are happy and relieved that the second petitioner is in court. It will appear as well. But there are procedural issues of compliance, which I believe we can proceed with still, now that the DCI is here. There are issues about the modus operandi because these cases are becoming so many. And directions of this court, after listening to the answers the DCI may give, may help save the court the time we have spent. So we are seeking your indulgence that now that the DCI is here, we at least can deal with matters of compliance today. And any other procedural issue we might wish clarification from the DCI. And I want to say when an application like this comes to court, it is not just about the person for whom the matter is brought. It's also about for the rule of law and for the safety and well-being of everyone. So we'll be happy to proceed with the DCI.
Just a minute, Mr. Bitter. Senior Counsel, I look at my directions, and I want us to look at them. They were very clear.
I have a copy.
Yes, they were very clear on what I wanted the DCI to come and do. We are here only for one subject.
I'll read number 5.
I'm aware of my directions. I'm looking at the subsequent directions that I issued the last time we were here. Why I needed the DCI here.
Okay, yes, I'm seeing now number 5.
So can we go beyond, Mr. Kibe?
Yes, ma'am.
Can I go beyond what I wanted this morning?
I believe that whatever hearing is there today is subject to the directions that were made, but I cannot say.
Because you've made a specific request.
Yes, I have.
And you'd want to participate
Yes,
in anything that goes on.
Yes, but the petitioners can speak for themselves.
I agree.
Yes.
I have the petitioner, second petitioner in court.
Yes, the second petitioner is in court.
I wanted him dead or alive.
Yes, that is.
I have him alive.
Yes.
What else do you want me to do once I have him alive? You have requested that you need time with him.
Yes.
And it's important.
Yes.
So, Senior Counsel, I think, I'm not deciding, but I think the fairest thing to do is to allow the family and you lawyers have a conversation with the second petitioner, and then after you have that conversation, then we will decide how to proceed next. My intention this morning was to have him, and I have him. So I present him to the Kenyans, that he's here, he's alive. So any other thing is now after you people take fresh instructions. Am I right? Who thinks we are not?
We are most obliged. It's just that we thought we could take advantage of the presence of the DCI, because apart from that, there were compliance issues.
Yes, just let them finish, Mr. Peter. I will come to your side.
Issues which we raised on the...
We are not doing the petition. I still have the petition to dispose of.
Okay, then with that I will see.
We are at the preliminary stage. We were looking for him. We have him.
And we are relieved.
So can we still have a petition to deal with, Mr.
Yes, my lord.
Kabata?
In fact, my lord, we still have a petition to deal with.
Yes.
And in the interim on that application, we are relieved that the second petitioner applicant has been found. From our position today, we had come to dine, and our food is here.
You want it?
I'm saying, my lord, we had come to dance. Since our work as lawyers and our witnesses in court, we may miss this opportunity. It is a golden opportunity. I am reading this in line with what was found in by your brother Justice Mugambi in petition E436 of 2024 and your brother Mwamuye in E0714 of 2024, that orders of the court are not pious orders. They have to be complied with. Now that the Director of Criminal Investigations is here, there may be questions that we may need to ask to prepare ourselves in the debrief that we come to explain to court. He may elect, as we have seen before, my lord, on the day when, and his brother, Mr. Masengeli is here, on the day when the court wants to exercise its prerogative power, the petitioners are usually found. It is a modus operandi. Every time when they are almost getting to the corner in court, the petitioners are found. Now, since the director is here, my lord, we intend...
No, I will give directions.
Yes, my lord.
You are making requests,
Yes.
but I will give directions. But I want first to take into account the request by the family.
Yes. Yes.
It's paramount to me.
Absolutely.
They want to talk to the second petition. We still can ask him to come. But if you want to ask him questions, I'm here, he's here.
And your directions, my lord, are very well noted. And
No. If you want, he's here. And I'm here.
My lord, just
So,
if I may be able
let's have it in order that we have the DCI, we have the petitioner, right? The person I wanted. You want to ask him questions? He's here. I'm not saying you will not. But I want us to agree how we proceed. Does the family have first opportunity to talk to him? There may be something.
I'm actually drawing from your wisdom, my lord, that in this particular instance, as we left last time, the primary concern was the life and liberty of the petitioner, second petitioner. And we are glad that he's here. He's alive, he's breathing. At this point also, Mr. Min has acted to comply with your orders, he's here. And on the petitioner side, we were ready to cross-examine. But the family has made a request, which is also reasonable. You have a traumatized citizen who, for all intents and purposes, may be in a daze not even fully understanding what we are saying or going through. So the request to debrief, give him time to compose himself, to understand his circumstances under which he could be traced. Then we reconvene. Once the second petitioner has debriefed with counsel, probably gotten medical attention, and is ready now to participate in the petition, all parties come back here. And my lord, the only point you are stressing, which now I'm guided again by your counsel, is the presence of Mr. Amin. We may need him. My vice president, I as deputy designate, my vice, would have wished it happens today. But in the circumstances, it may not be possible.
Oh, he's here.
No, I'm talking of...
And we are here.
And I was going to say, my lord, I was actually coming to that. And also recognizing that he's in charge of criminal investigations in the entire country. And getting him is sometimes difficult. And now that he's here, at least to the extent of the first petition as cancelled, we can take our bite at the cherry when it is still fresh and here. And we question him, we preserve so that we don't fall of instances where when we seek him to come to court, he says he has gone for an operation in Baragoy. Which may be a genuine operation or not genuine, sometimes happen. So having blocked his diary for today, no prejudice will be suffered if we proceed with it today. But if the court is minded to consider the family request, we will equally be guided. And also, my lord, of import in this particular instance that we don't lose focus on.
Yes.
In the replying affidavit signed by the respondents in paragraph 20,
I have two.
The affidavit sworn on 30th of June 2025 by Samuel Ite.
Paragraph 20.
Paragraph 20.
Yes.
There is a live issue which I will not wish that we gloss over. If the second petitioner were to leave court today, there is a real danger that he may be arrested or detained by the respondents. On his behalf and in the interest of justice, I'll pray that when the court is making directions as regards to the second petitioner, the court consider issuing an order restraining his arrest. If any arrest ends up in court,
yes,
and he can be bonded to attend to this court when required, so that the question that should be of our primary concern at this point is him getting medical attention and social support.
In fact, my lord, will be happy if the director will just tell us that they will not arrest him for today, so that we go probably just also for the court to feel the presence of him.
I confirm the application for protection of the second petition at this time. It is also one you are going to make, so I had to make it in giving these directions.
Yes, Mr. Bitter.
Yes, my lord, thank you. My lord, I have an application to make. The first application I wish to make, my lord, is that if the court will be gracious to summon the deponent who swore an affidavit in support of the petition, one Florence Muturi, to attend court during the next hearing for us to cross-examine her. Because, my lord, there are certain facts that she points to that have led us.
Which affidavit?
There are two affidavits. The first one was sworn on the first day of July 2025. 2025.
Which date?
1st July 2025. And there is another one sworn on the 24th day of June this year, my lord.
So, Mr. Bitter, we should begin sequentially, the earlier to the latest.
The first one is sworn
24th
day of June 2025.
and the first.
Yes, that is the first affidavit. The second one, my lord, is the one to on the first day of July 2025.
Okay.
Both in support of the petition
Yes.
and the motion.
Yes.
Secondly, my lord, in terms of the directions of the court, my lord, now that the DCI has come in answer to those summons, we pray that those directions be discharged as regards the appearance of the DCI. And thirdly, my Lord, the DCI, in light of what has been stated, would wish to be given an opportunity to speak on behalf of the Directorate.
To have an opportunity?
To address you, my Lord, on behalf of the Directorate, because they feel that they have not been treated fairly as regards this case, and they need to be heard. An opportunity to be heard as regards all the issues raised. My Lord, fourthly.
So, I didn't get you.
Yes, my Lord, he wishes to be heard. He wants to be heard.
Today?
Today, my Lord, before you. Now that you summoned him. He wants to be heard because
yes,
they have not been treated fair in this matter.
They say so.
Yes, they need an opportunity really to state the facts as they are. My Lord, an application has been made orally. I am not privy to the basis of our application.
Which one?
The one for, there were several applications made by Mr. Kibe and Mr. Wakabata.
Yes.
Yes, and Mr. Willis Otieno. I pray that we make a formal application so that we have an opportunity to respond.
You are mixing up.
Let
me see whether we are speaking.
Correct.
Mr. Kibe made a specific request on behalf of the family that they would want time with the second petition. That's number one, and that's the primary application I had from Mr. Kibe. So what do you say to that? Not mix his and the other people.
My answer is simple.
Yes.
Mr. Kibe is not a party in this proceedings. He is not a party in this proceedings. I have no problem with him meeting the second petitioner in whatever capacity out there. But he is not representing any party in this proceedings. If he was, I would be in a position to respond to an application made by a party.
Okay.
Yes, ma'am.
So you're not able to respond?
My response is Mr. Kibe is not a party in this proceedings. Okay. He cannot make an application in proceedings that he is not a party.
Okay.
There is the application made by Mr. Willis Otieno, my Lord. And I believe, my Lord, if you look at the notice of motion, filed by the petitioners in this case.
Yes.
There is a prayer that was sought for the unconditional release. And prayers of habeas corpus, my Lord. If you look at prayer 8, my Lord.
That's in the original motion.
It is in the notice of motion, my Lord, the one that gives direction.
Yes.
They sent 24th of June.
Yes. Yes.
You've seen it, my Lord?
Yes.
Yes.
Which one are you referring to?
I'm referring to prayer number 8, my Lord.
Yes.
Prayer number 8.
Yes.
So that, my Lord, This is the prayer that has been sought. We have responded to this motion, my lord. And we are ready for it to be urged, my lord, inter partes. And I believe it is only fair that we deal with this motion, my lord, before we consider any other oral application. I believe that you're coming for directions, my lord, so you can give directions on the hearing, so that we conclude with this interlocutory application. I think that is my brief response.
My lord, in response.
Before you respond,
Yes, my lord.
I want to find out whether I got Mr. Peter well. What you say, Mr. Peter, is that you want the DCI to be allowed to speak.
Because you called me.
Because
Come on,
yes,
please.
yes. I'm not saying I didn't call him. Why are you here?
Yes.
That's all I want to hear, because the petitioner, the family has a specific request. The petitioners, counsel for the petitioners have their way of looking at things. So I want to know whether you agree that we hear him today, despite the request from the petitioner's family.
Despite the request, my lord, because of his schedule.
I have no problem. I just wanted to know whether that's the way you would want us to proceed, so that I give directions.
Yes, please.
Mr. Mungai?
Yes. My lord, first of all, it is very strange for the Honorable Attorney General, representative of the Attorney General, the Constitution in Article 156 of the Constitution, I believe sub-article 6 talks about the Attorney General shall promote, protect, and uphold the rule of law and defend the public interest. This is a habeas corpus application to the subject matter of the petition.
Yes.
In a habeas corpus application, and by the nature of habeas corpus, the family is a necessary party, and invariably habeas corpus applications are instigated or instituted at the behest of the family.
Yes.
And therefore, for purposes of these proceedings, where the second petitioner is indicated as Ndiang'ui Kinyagia, was not there to give instructions that should be construed as the family of Ndiang'ui Kinyagia. So the family of Ndiang'ui Kinyagia is already a party. And if it was not expressly, it is a necessary party whose right to participate is inherent in the nature of habeas corpus.
Yes.
But if, for whatever reason, it is necessary to comply with technicalities, notwithstanding Article 159 of the Constitution, that litigation, particularly under this jurisdiction, shall not bear regard to undue technicalities.
Yes.
I wish, pursuant to Rule 10, Sub-Rule 4 of the Mutunga Rules, to make an oral application for the family of the second petitioner to be added to the proceedings as a third petitioner. But the primary position is that they are already parties, if the second petitioner is a party. My Lord, and that is pursuant to Rule 5. Is it Rule 5? Rule 5 of the Mutunga Rules. That this court has jurisdiction under those two rules, 5 and 10, to make such an order. And my Lord, the last one is technically is a question of common sense and propriety of proceedings. The notion, as urged by the Attorney General, is that you can have proper habeas corpus proceedings in which your lordships can lock out the families and their representatives from speaking would be completely unusual. The only issue that we need to clarify is that when I advised that Lilian Wanjiko Getonga to file an affidavit, I advised that she would come as an interested party. So for purposes of Lilian Wanjiko Getonga, who gave us the information, will appear as an interested party. But now that he is there, and when we speak to Ndiang'ui, the second petitioner, then we will be able, for purposes of completion of the habeas corpus proceedings, to be of further use as indicated to the court. Because all of us, even out of curiosity, want to know where was he? And why has he also just appeared the day before? We want to know that. And nothing else for purposes of curiosity. Therefore, we need to talk to him, as we had requested, but we can formalize the proceedings because we need to apply for his protection. You must bless
Madam, do you have a right to reply on my application?
Which one?
The question of the liberty of the individual and the need for him to be given an opportunity to get medical attention. He looks physically traumatized. I'm not a medical expert, but applying my elementary knowledge of
So if you continue talking, and he wants medical attention, what are we doing to him?
That's exactly what I was going to say, that we should not talk too much, but we should by issuing the order that allows his liberty and an opportunity to access medical help.
Where I am, I think we are losing the point. I have the DCI in court. I have the petitioner in court. The family has requested to have a conversation with the second petitioner. I have parties who want to keep us here. We want to hear the DCI. Mr. Bitter says they were not treated well. He will tell us. The other side wants to cross-examine the DCI. So how do we proceed? Which one should we give preference to? it is something a decision you have to make conscientiously. If the health of the second petitioner is primary, or do we keep the DCI here?
I don't.
My Lord, I think we should give way to the family, and parties, those who are needed by the court can come on the next date. The application was about the well-being of the second petitioner. And I think, in all fairness, we ought to give way. Even though we were rallying to go, we should hold our breaths.
Mr. Bita,
Yes, my lord.
how many deponents do I have? I have 3 affidavits from Buire. Is it mistaken? There's one called second respondent's father affidavit. That Buire seems to be the same.
No, my lord, the first affidavit is by Samuel King.
That I have.
Yes.
That's the original.
That's the
Yes,
original.
that one we have.
Then we have a further replying affidavit by Leonard Ciele. That one is sworn on the 2nd day of July.
So is that one of Bwire?
Yes. So there's Leonard Siele, and then there's Patrick Bwire.
The first one is?
The first one is by Samuel Kitigi.
Yes.
That is, these are the first ones.
Yes. Yes.
The second affidavit is by Leonard Siele.
You don't have that one?
You don't have it.
The third?
The third one is by Patrick Bwire.
I have 3 copies by Patrick Bwire.
Maybe they printed the same thing. But we'll supply, we have copies of it.
So how many? Can I check? Can I see it online? All these stuff from Bwire. Okay, but see, can I check it? Did you upload the one of Siele?
Mr. Marwa actually uploaded it. He's here, I can speak for himself. He personally uploaded.
No, you are now the lead.
Yes, ma'am.
I'm told you are his senior.
Yes, and I trust him.
So how do you throw it back to him? Because you are the one, I'm looking at the system.
Yes.
It is the same affidavit by Bwire that was uploaded. It was uploaded twice. Someone else who can assist me, maybe we are wrong on this end.
Your Lordship, there is a...
Let's check.
I've given a physical copy right now.
No, it has to be here. Because this is the 5. Your people can upload it now. But let's see the have you seen the one by Sele?
Yes, yes, my lord.
You have one by selling.
Yes, yes.
We don't have it here.
My lord, he can re-upload it.
What's the problem? It's loading. We are still trying to confirm. You know, the systems are sometimes slow. See that? Yeah, it's here that you uploaded Buire twice. So I'm sure it is because of the urgency. So anything else?
I wanted to address your question on an issue that Mr. Bita has raised, but my senior, Mr. Papere, I see is in court and has better particulars of that. He's 38 years in the profession, my lord, and to me, that counts for something.
Quickly, please, my lord. Leaving what my vice president has said, I am the second senior most after senior counsel Karua. But I just wanted to bring something into context on the 4 applications made by Mr. Bita The first one was on the summary of the CEO of the Law Society. I appear together with the rest, for the Law Society and the second petition. As to that application, the Law Society has no objection in respect of the first application by Mr. Bitter on the question of cross-examination, which can be dealt with at the appropriate time. What I am worried about are the second and third applications by Mr. Bitter because they go against each other. The second application was to discharge the personal appearance of the DCI, but the third one is to give him an opportunity to address court, which is sort of supporting what my other learned colleagues had said about having a bite at the cherry today. So that third application also supports what the other parties were saying, that he can be able to say something. He cannot just say it and go. He may have to be asked some questions in relation to that before he is discharged. So while dealing with those two applications, you may have to consider how to balance the two of them in relation to giving him the opportunity and then thereafter discharging him and whether he will be cross-examined. Then as to the question of a formal application which is filed by Mr. Kibe, I think that has been addressed, and that was the fourth lane of Mr. Bitter's application. So those are the the four issues I wanted to bring to context for purposes of then when your Lordship is giving directions, then you can be able now to balance what Mr. Bitter requires, what we also require, and the fact that at a later stage, since the other affidavits are supporting the petition, they can be dealt with in the main petition, and the deponent, including whoever may be required, a notice can be given as is required by law that we will want to cross-examine you on these allegations or these depositions in your affidavit dated this particular date. That will be all.
Let me make it clear that the court is never addressed. It is the lawyers who address the court on specific items. So if the DCI wants to speak, he will take to the witness box. He's here as a witness of the court. He's led what he wants to say, and then he will be subject to cross-examination.
Thank you.
Those are the directions. If we are going that way, we clear the way for that. Bearing in mind, I have a specific request from the family.
Yes.
So if you want us to go that way, he will take the stand, be led for the reasons that the court directed he be here, nothing more.
I think my learned senior, my learned counsel can be able to now.
So you look at the directions are issued. He was to be here for a specific mission. We are not digressing any other issue. If we are sticking to that, that's what we are doing, Mr. Bitter.
Yes, but let me address you on that because I've received some instructions from my client. He says he wants to respect the wishes of the family. Now that he has answered the summons of the court to appear, and the second petitioner is present, that you discharge him to start through summons of availability.
What is he telling you, Mr. Bitter?
No, he's telling me to abandon the other applications, my lord.
It's already on record. And all of the applications is already on record.
So as regards the DCI, my lord, is that you discharge him. He doesn't wish to oppose the wishes of the family. Those summons are actually transferred.
out of that application by Mr. Vita, I hope we'll be given an opportunity to reply.
Mr. Bita, you have filed all you wanted to file in response to the petition.
To the petition, no. I was just dealing with this aspect because you know there are other parties. The accusations against other parties were
So you have not filed responses to the petition?
as regards the other parties. But as Attorney General and the Cabinet Secretary for Interior. Although today is Thursday, by Monday I will have filed.
You will have filed. I'm suggesting that we go directly to the petition.
That is okay, Mama.
You agree?
Yes.
The petitioners?
We are fine with that.
Well, I can also file an appeal.
That's a response, Mr. Bita, in my court. Ask Mr. Maro, I think he comes to my court so often. POs are our responses to the petition.
I'm not been to your court longer than Mr. Maro.
I don't know when last year in my court. But I'm sure you know.
Yes, Mama.
So next week, so I can give you 7 days?
Yes, madam, that will be okay.
Senior Counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think 10
10 will do.
would do, yes.
We are dealing with the petition because there are specific issues we are raising.
Then make it maybe
15?
15, yeah.
Mr. Bita, would 15 be fine with you? Okay.
My Lord, before you give your directions, perhaps you consider that the case be disclosed by both submissions and viva voce evidence, because we still have that cross-examination issue.
Yeah, so does it make sense to file submissions before?
It does not.
Doesn't?
We actually should have the cross-examination before submission. Submissions are a wrapper.
Yes, sir.
Yeah.
That's why I'm looking at, we have to change that. Want us to agree on a date we can have the hearing? This matter will be heard through viva voce evidence. We don't have dates. To try to see, because of the nature of this matter. Senior Counsel, how long will you take to do your witness?
I think
We already have the affidavits. We will have the affidavits.
Yeah, but we are not even talking of our own case. We are talking of cross-examining DCI and the deponent.
I'm talking of your case. How much time will you take to present your case?
I think our 1 day then.
1 day?
Yeah, not more than 1 day. Yeah. It could even be less, but to be on the safe.
You know, I have affidavits already. Yeah, they will come here and adopt affidavit and be cross-examined. Yeah. That's the way we proceed.
Have requested for somebody without any affidavit. The DCI. Because it is officers who swore, yet.
We will reach there.
Okay.
Let's stay with you.
Okay.
Yeah. I'm looking for your side.
Yeah.
Don't worry, because they will come and they will cross-examine. Do you have it?
3 hours for highlights, but cross-examination will be a day plus. We had prepared that.
So which day? Are you suggesting there are days you come without preparing?
No, but because of the menace of the problem we are talking about, we had come loaded more than usual.
Because of the threat that will take so long, I'm suggesting 17th and 18th of July for hearing.
May I request we push another 2 days? I have a personal problem. I'll be out I'll be returning on 16th and 17th. I'm in Kampala. So if I could request.
So that, do you have any other
And
dates?
Kampala, I'm lead counsel.
No, you said you are not available, so we... When are you in Kampala?
On the 17th.
17th. Will you fly back? You don't know.
It's a day trip.
No, will you fly back the same day?
Yeah, it's a day trip. That's what I'm saying. Going in the morning, back in the evening.
So you can take 18?
Yeah.
You can take 18? And then 24.
No, they will come in.
So we will have to stagger it. We take 18th, and then we proceed on 24th. How is that? Mr. Bitter?
18, that's okay.
24th. That's okay.
Some time allocation or not?
I will come to that. Let's just agree.
A doctor from China to show the world how to slow down aging.
So I suggest we start 10:30 each day.
That's okay, madam.
That's okay?
That's okay.
So the court issued specific orders and directions on the DCI to come to this court today and explain the whereabouts of the second petitioner or produce him. Today, the second petitioner has been presented to court by the family, and the family has made a specific request to have time to speak to him and get to know what has transpired, and they also give instructions to the advocates. Mr. Bitter, for the respondents and the DCI in particular, does not oppose this view, and since today was for explaining the whereabouts of the second petitioner, and now that the second petitioner is in the court, it's proper and appropriate that the family has time with him together and the advocates and take instructions and possibly have him treated. For that reason, we issue the following directions. This petition will be heard by way of oral evidence. Respondents have 7 days to file responses to the petition if they have not already done so. Once they serve, the petitioners will have 7 days to file a supplementary affidavit if need be. The families granted time to have the petitioner with them and taken to hospital for medical attention. This matter will be heard on the 17th and 24th of July. 18th, sorry, I had already 18th of July and 24th at 10:30 a.m. both days inclusive. In the meantime, the police shall not arrest the second petitioner, Ndiang'ui Kinyagia, since he is now a petitioner in this matter and may be required to testify. The second petitioner may be presented to the DCI officers to record a statement if need be, and he should be presented by his advocate, but he should not be arrested or detained until further orders of this court. Thank you. So we meet on that day. Please comply with the directions. Thank you.
Sana. CJ. Tuko live. News inaanza, wataitumia. Get some good shots. Mambo. Niko allowed kufanyia live hapa. Live ya NTV. Naweza ifanya nikiwa tu hapa. Kuongea saa hii